So good morning. Is it still good morning?
It's good afternoon by 1 minute.
I'm sorry. Good afternoon. Thank you all for coming. Thank the chairman for doing this. Just one little word of logistics. He is going to speak and take questions, and then I guess leave. And we're then going to eat. We're not going to eat while he is trying to. Everybody knows who our speaker is. He's chairman of Judiciary. He was previously chairman of the Agriculture Committee, and he is also, co-chair of the Congressional Internet Caucus and chairman of the House Republican Technology Working Group. So he's got his fingers in quite a few pies, but from my point of view, there's no pie more important than the judiciary pie and the work that they're doing in the bill that he has introduced, the Regulatory Accountability Act, which is going to try to chip away at the administrative state, which has gotten way out of hand. And the Federalist Society is running a project on Article 1 to try to help make suggestions for how Congress can reclaim some of the lost ground lost to the agencies. And in that regard, the chairman's bill does tackle the Chevron issue, which is where so much of the abdication, in a sense, the transfer of authority, has been captured by the agencies and taken far further, I think, than even Justice Stevens thought he was setting up in 1984 when he wrote the Chevron opinion. So the Article 1 project is very important. The role of Congress is very important because the Chevron issue, the deference issue, where and even in some cases the agencies get to overrule courts, which has really got it reversed. The stepping stone for that is the broad delegation that often accompanies statutory grants of authority, which allows the agencies to jump into a hole and just grow it as far as they can grow it. So it's very important to get a handle on the Chevron issue, and I think it's no coincidence that last night Congressman Goodlatte was there, the chairman was there, that the president picked Judge Gorsuch, who has probably been more articulate than any of the possible candidates, more articulate about the dangers of the Chevron case, which the chairman's bill directly addresses. So without taking any more of his time, would you please welcome Chairman Goodlatte?
Well, good afternoon. Boyden, thank you for that very kind introduction. It is an exciting time to be serving in the Congress and to be working here in Washington, D.C., and it's an honor to be here with the Federalist Society and at the National Press Club. I find that my work as chairman of the House Judiciary Committee is a pursuit similar to the work here at the Federalist Society. For over 3 decades, the Federalist Society has been devoted to the preservation of our constitutional republic and the principles of individual liberty, the separation of powers, and the rule of law. As chairman of the House Judiciary Committee, I am equally committed to safeguarding and promoting these core values. It's both fitting and a privilege to lay out the committee's agenda before you today. The Judiciary Committee plays a particularly critical role in advancing pro-growth policies for hardworking Americans, ensuring that America's laws are efficient, fair, and enforced, and guarding against the consequences of executive overreach. Under my leadership, the Judiciary Committee will continue to advance an agenda that is focused on making America more competitive and free. Our nation's capitalist system was designed to reward innovation, efficiency, and persistence so that hardworking Americans would be uniquely situated to succeed both domestically and internationally. When the American economy is thriving, there are more job opportunities, higher wages, and lower prices for Americans. However, for far too long, our federal government has continued to pile unnecessarily complicated new burdens and red tape on American businesses, which have effectively tied the hands behind the backs of our nation's small businesses and entrepreneurs. Viewed from another angle, these burdens on U.S. businesses subsidize our foreign competitors. It's long past time to untie these binds and unleash American ingenuity. As House Judiciary Committee Chairman, I will seek to restore accountability for and provide relief from excessive regulation for our nation's small businesses and job creators. Federal regulations now impose an estimated burden of nearly $2 trillion per year. That equals roughly $15,000 per U.S. household, over 10% of America's GDP, and more than the GDP of all but 8 countries in the world. Unfortunately, over the last 8 years, the Obama administration doubled down on its determination to create a regulatory state by adding tens of thousands of regulations, including many within the last months of his presidency that could have far-reaching effects for years to come. The problem with excessive regulation is that it hurts all Americans. It leads to higher prices, lower wages, fewer jobs, less economic growth, and a less competitive America. But it's a new day in the United States. While I have been calling for these reforms for years, we now have a president, a Senate, and a House focused on enacting laws to reduce the regulatory burdens that our nation's small businesses are facing to get more Americans back to work and help grow our economy. Last month, the House approved a series of bills to rein in unnecessary red tape, create transparency within the rulemaking process, and restore power back to the American people. Given our commitment to curbing the regulatory state, it's no surprise that optimism among America's small businesses has soared by the most since 1980. To make America more competitive again, we must also make our legal system more efficient and fair. America's legal system is considered the costliest in the world. In fact, one study found that liability costs in the United States are more than 2.5 times that of Eurozone countries. While we must protect the ability of Americans to seek redress through the courts when they are truly damaged or injured, there are measures we can take to reduce the wasteful burden that truly frivolous lawsuits impose on American competitiveness. Like excessive regulation, frivolous lawsuits are a drain on businesses, entrepreneurs, innovators, and hardworking Americans. We can and must do better. Over the next Congress, the House Judiciary Committee plans to reform the litigation system by seeking to reduce frivolous lawsuits, making it harder for trial lawyers to game the system, and improving protections for consumers and small businesses. We'll also work on reforms to discourage abusive patent litigation and keep U.S. patent laws up to date. Collectively, these reforms will help alleviate the wasteful burden of unnecessarily expensive litigation costs, thereby freeing small businesses to flourish, unleash innovation, and create new jobs for Americans. The House Judiciary Committee will also build upon its review of our nation's copyright laws to ensure that America's global leadership in creativity and innovation continues in the 21st century and beyond. At the end of 2016, we issued our first bipartisan proposal to ensure the Copyright Office keeps pace in the digital age. Among the reforms contained in our first proposal are granting the Copyright Office autonomy and requiring it to maintain an up-to-date digital searchable database of all copyrighted works. This proposal is the first of what we intend to be numerous policy proposals to reform aspects of our copyright laws. Furthermore, to increase our competitiveness, we need to get our fiscal house in order. The federal debt is nearly $20 trillion. That's over $61,000 per person. For years, the federal government's mantra has been borrow, spend, rinse, and repeat. The current path is unsustainable, and we must end runaway government spending. One good first step would be to pass a balanced budget amendment. Since 2007, I've introduced proposals every Congress to require a balanced federal budget and prevent Congress from spending more than it receives in revenues. These proposals have received strong support over the years, and I'm hopeful that we can address this problem soon so that we do not continue to impoverish our children and grandchildren by passing a massive debt on to them. The Judiciary Committee also has the solemn responsibility to ensure our laws are fair, efficient, and enforced. Under my leadership, the committee will continue to advance an agenda that ensures our federal criminal laws are designed to appropriately punish wrongdoers, are effectively and appropriately enforced, safeguard civil liberties, increase public safety, and work as efficiently as possible. Both Ranking Member Conyers and I remain committed to passing bipartisan criminal justice reform. We must rein in the explosion of federal criminal laws, protect innocent citizens' property from unlawful seizures, and enact forensics reforms to identify the guilty and quickly exonerate the innocent. We must also reform sentencing laws in a responsible way and improve the prison system and reentry programs to reduce recidivism. Additionally, it's imperative that we continually examine federal criminal laws to ensure they protect civil liberties while also providing law enforcement with the tools needed to fight crime and keep us safe. This Congress, the committee will once again work to reform the Electronic Communications Privacy Act of 1986. This law is outdated and contains insufficient privacy protections for Americans' email communications in today's digital age. We must modernize this decades-old law to better protect constitutional rights without impeding law enforcement's efforts to protect public safety. In this same vein, the committee will also continue to explore solutions to govern law enforcement's access to data stored overseas. The Judiciary Committee will also seek to reform and reauthorize Section 702 of the Foreign Intelligence Surveillance Act. The committee has a strong record of enacting solutions that protect both privacy and national security. When Section 215 was up for reauthorization a couple of years ago, bipartisan leaders of the Judiciary Committee led the way to enact the USA Freedom Act. That law ended the bulk collection of metadata while ensuring the law enforcement community has the tools needed to keep us safe. Section 702, set to expire at the end of this year, with that section, committee leaders will again work together in a bipartisan fashion to ensure America's privacy is protected as the government lawfully surveils the online activities of foreigners seeking to harm us. We must also ensure our laws protect the most vulnerable among us, the unborn. Since Roe v. Wade, nearly 60 million babies have been aborted. The House Judiciary Committee will continue its work to save more innocent lives by enacting measures to reduce abortions, help promote alternatives like adoption, and ensure taxpayer dollars are not used to fund abortions. The House Judiciary Committee also has jurisdiction over our nation's immigration laws, and we will strive to restore the rule of law and make the immigration system work better for our country. Throughout President Obama's tenure in office, he refused to fully enforce our nation's immigration laws and used his pen and phone to unilaterally rewrite the law. These actions are not without cost. They ignore the will of the American people, violate the Constitution, allow criminal aliens to evade the law, make our communities less safe, punish legal immigrants, and encourage more illegal immigration. Fortunately, President Trump is rolling back these abusive and overreaching actions and is committed to enforcing our nation's immigration laws. This will help stem the tide of illegal immigration and restore integrity to our immigration system. But Congress has an important role to play. Nearly everyone agrees that there is room for improvement in the immigration system. We must strengthen the interior enforcement of our immigration laws and remove the ability of any president to unilaterally shut down immigration enforcement. We need to ensure criminal aliens are detained and deported and end dangerous sanctuary policies that jeopardize public safety. We must also reform the asylum system, which has been increasingly abused, and make sure unaccompanied alien minors who make the dangerous trek to the United States are safely returned home. The House Judiciary Committee will also work to improve the legal immigration system. The United States has the most generous legal immigration system in the world. However, we select less than 12% of immigrants on the basis of education and skills they can bring to America. And it's only 5% if you do not include their accompanying family members. Other countries, such as Canada, the United Kingdom, and Australia, select over 60% of immigrants based on skills. In order to remain competitive in the global economy, this must change. Additionally, we also need a workable agricultural guest worker system so that when our nation's farmers cannot find U.S. workers, they have access to a legal workforce and are able to continue growing our crops and economy. Lastly, I want to make clear that the House Judiciary Committee will continue its important oversight work over the course of the next Congress. As explained by James Madison in the Federalist Papers, our constitutional government only works when each branch checks and restrains the others from exceeding their legal limits. Men are not angels, and the House Judiciary Committee has a duty to continue its vigorous oversight of both the executive and judicial branches. We must ensure that they are bound by their constitutional limits so that we protect individual liberty and the separation of powers now and for the generations to come. The topics I outlined this afternoon are by no means exhaustive. The House Judiciary Committee has much important work to do over the next 2 years, including addressing many additional issues that have not been discussed today. In closing, with the President, the Senate, and the House aligned, the American people have spoken, and we have a unique opportunity to deliver on what Americans have been asking for years. I'm excited about the prospect we have before us to make America more competitive, deliver more jobs to hardworking Americans, protect our national security, and make Americans more free. It's truly an honor to serve our nation as chairman of the House Judiciary Committee, and I look forward to continuing working on the significant issues facing our great nation with the new Trump administration. Thank you for letting me give those remarks to you. And now I'd be happy to take questions. Yes, sir.
You can wait for the microphone. William Hoffman from Tax Analysts. I'm wondering what practical, specific changes you expect from the removal of Chevron deference if your H.R. 5 is taken up by the Senate and signed by President Trump.
True. H.R. 5, as you may know, is a consolidation of 6 different bills, one of which addresses the Chevron deference issue. Our purpose here is to restore separation of powers and to make it what we think would be more likely that congressional intent will be reflected in court decisions about government regulations. So as you know, the complaint about the Chevron decision is that the court gives undue deference to the regulators. The very people who write the regulation get to tell the court what should be the proper interpretation of those regulations. We think regulations in every instance are built upon laws passed by the Congress of the United States, and that the court should exercise its judicial independence and its discretion to review the regulation, not from the standpoint of what the regulator, the person who may be incentivized, not only to write it the way it's written, but also to interpret it the way they prefer to interpret it, and to actually look at the underlying statute and see if the regulation comports with that statute from an independent standpoint, which is what we expect of an independent judiciary.
Is there though a specific regulation you can think of, either pending or in the recent past, that you think this would have made a different turn on, would have had a different result?
I couldn't give you any specific one as we speak right here, but if you'd like to follow up, I'd be happy to look at that and see if I can give you examples. I'm sure there are many, but I don't have them right here to give you right now.
Understood. Thank you. One follow-up, though. You mentioned you did not mention what the judiciary's plans might be concerning the future of the IRS commissioner. Have you been approached by anybody about continuing the impeachment proceedings? What is your feeling about those proceedings?
There have not been discussions in the committee with regard to the future of the IRS commissioner. I have, as have a number of other people, expressed my belief that President Obama should have fired him and that he should resign. As you know, his term of office does not expire until late this year. So my recommendation to the new administration would be to make that change sooner rather than later. I think that his continuing on is a reflection of a lack of attention to a grave concern about how the protection of individuals' freedoms were infringed by the IRS, abusing their authority with regard to the approval of applications for various tax statuses that started before he became the commissioner, but was not solved, and quite frankly, the investigation was stymied during his term and has never been brought to fruition. So that is my recommendation to the administration, but obviously we have a new president entitled to choose a new IRS commissioner and do it as he sees fit. Let me get the gentleman over here.
Mr. Chairman, thank you. Could you give us a sense on where the committee will go on patents this year? Will H.R. 9 be reintroduced in substantially the same form, or will you be taking a different approach this time?
We are definitely going to continue to pursue patent litigation reform. Fortunately, the courts are also reviewing our patent laws, particularly as they pertain to litigation. And so some of the decisions they have made in recent years have had what I think is a positive impact on reducing the problem of patent trolling and making sure that we have a system that is more reflective of incentivizing people to innovate as opposed to attempting to profit from a false claim about a patent or a process whereby you threaten litigation that is extraordinarily expensive in this field and then say, well, we'll take $10,000, $20,000, $50,000 to settle. There's a big industry, I'm told a $1 billion plus industry to do that. One of the issues the court recently agreed to take was with regard to the issue of venue. And if you followed this closely, you know that in the legislation we introduced and passed out of the Judiciary Committee this past Congress, we added venue reform to that. So we are looking to see what will come from that court case, which we expect to see a decision on by mid-year, and that may inform some of our work. But we're also looking at a number of other areas, and again, reaching out to people who have been affected by this to both make sure that the litigation process is fair, it's not abused, but also to make sure that creative works, inventions are protected, whether the inventor is large or small. Look at this gentleman right here.
Joe Marks from NextGov. Thanks for doing this. First, can you expand on what you hope will happen with ECPA reform? And then second, do you expect either the debate over encryption or over Rule 41 and FBI hacking powers to return this Congress? And what will be the Judiciary Committee role?
Well, ECPA reform, the Electronic Communications Privacy Act, is badly needed. This is a law that was written in the 1980s. Electronic communications have changed just a little bit since the 1980s, and we worked very hard to make sure that the law reflects the public's modern understanding of how their data is stored. Much data that is today stored in the cloud or by third parties by some other means used to be something that either wasn't stored at all or you kept in a file drawer at your home, or maybe it was at the bank. Today, the public's understanding that this is held by somebody other than themselves has grown and their expectations have grown. So the requirement of a warrant in almost all circumstances to get access to this data is, I think, a good thing. We worked very hard to address law enforcement's concerns, and when we produced the bill this past year, I was not only pleased but surprised that we got every single member who voted to vote for the bill, 419 to 0. That's a very good start. We regret that the Senate did not take up the legislation. We wish they would. If they take a somewhat different approach, we would not discourage that at all, because then we could sit down and work out the differences between the House and Senate bill. But our plan is to proceed with Mr. Yoder's bill that we passed by 419 to 0, as it was amended by the Judiciary Committee through the committee and then onto the floor of the House again, because we think that strong public support is still there, and we'd like to do that early to encourage the Senate to get busy and get it done this Congress. What were your other two?
Rule 41 and encryption.
With regard to encryption, we, as you know, are very concerned about this issue, both from the standpoint of protecting Americans' privacy and from the standpoint of making sure that law enforcement is not blindsided by criminals and terrorists who can effectively use encryption to hide their tracks. We held a hearing on the famous Apple FBI dispute. That led to the formation of a bipartisan and by committee, I guess. It's the Judiciary Committee and the Energy and Commerce Committee, a working group that produced a report at the end of the last Congress, which I think, if you haven't looked at that, we commend that to all of you. It's available on the committee's website, and we would like to build on that. So it's my hope that we'll continue that work in this Congress. This is an exceedingly difficult problem to address, because it's not privacy versus security, but it's privacy and security, because having strong encryption prevents many crimes, protects many people, but it also does create a problem for law enforcement, keeping us safe in other ways. So promoting new ways to help law enforcement address the problem of criminal use of encryption is our goal, but so is making sure that privacy protection and keeping people and their assets safe and encouraging American businesses to work to continue to promote this, because after all, we continue to see problems with massive hackings of banks, retail businesses, even the federal government, and therefore it's clear to me that more security, not less, is needed to make sure that people and their businesses can be protected. And Rule 41, tell me.
That's the Federal Rule of Criminal Procedure.
Oh, yes.
FBI hacking, law enforcement hacking powers.
Yes, well, we have not taken up anything specific with regard to that at this point, but as a part of this larger discussion, it certainly will be something that we look at. The gentleman with his one finger up in the air.
Claude Martz with that much. So I want to find out: are you planning on taking up again the measure to realign to more closely align the merger review procedures of the FTC and the DOJ, the so-called Smarter Act?
Yes, we are very much of the opinion that we're not achieving justice when the process by which antitrust issues with regard to businesses are reviewed in a different fashion by the Justice Department and the Federal Trade Commission. And therefore, we think there should be a common standard there, so that you don't have entities engaging in forum shopping, and you have a more consistent likelihood of result. So the Smarter Act attempts to accomplish that. It's passed the House on at least 2 occasions now, and we intend to bring it forward against this Congress, and we would urge the Senate to take a good look at that.
An idea when that would that be fairly early in the Congress, or later this year, or do you not have a
I
timetable
think
yet?
it will be on the earlier side, but I don't have a date that I can give you at this point. Yes, ma'am.
Immigration. What what's on the table in the coming session?
Well, there will be a lot on immigration. I think that.
I want to know all of it.
Well, if I weren't the last person standing between you and all these people's lunches, we would get into all of it. But let me give you the highlights. First of all, as you know, the president campaigned greatly on enforcing our immigration laws, and he's already taken a number of steps with more than one executive order related to this, and I expect we'll see more action on his part. He also has selected as Secretary of Homeland Security and as Attorney General of the United States two people that I think are by the book, enforce the law type folks. So I think that we will see that. I think as they do that work, they are going to discover that there are aspects of our immigration laws, enforcement laws, that need to be changed. For example, the employment verification system, the electronic system. It's a very good system, has improved dramatically over the last decade or more. It's now 99.7% accurate, but it's voluntary. About 600,000 American businesses participate in it, but not all do, and you might suspect that some that don't deliberately don't because they think it is 99.7% effective. Right. So we believe it should be mandatory, but we also believe that it needs to work out when 0.3% still results in a number of people coming up who may get a false positive or a false negative. Sure. So the legislation that Congressman Lamar Smith has introduced in previous Congresses, and I'm sure he'll introduce again in this Congress, will address that in an expeditious way so that businesses and individuals don't get caught in this catch-22 situation where you have a government agency after you if you don't enforce the law, and another one after you if you do, but do it in a discriminatory fashion. So that, I think, is an important tool that the administration will need, and we'll work on that. I think there are other things related to the abuse of our asylum system that I mentioned in my remarks. Asylum is a very important principle that America uses to allow people to escape from torture and other types of mistreatment in other countries. However, it is abused, and you can tell that's the case when people come here and they're fine until they're told that they're not going to be able to stay, and then they say, I want asylum. Well, in many of those instances, we're not sure that asylum is the appropriate measure. They're then released into the interior of the country, and guess what? Never come back to assert their asylum claim. So that needs to be reformed. Congressman Jason Chaffetz, a member of the committee and also chairman of the Oversight and Government Reform Committee, has legislation to do that. Judge John Carter from Texas has legislation to address the catch and release problem. And some of that may be addressed by change policies. I had the opportunity to be briefed by General Kelly, Secretary Kelly now, just yesterday, and he's focused on that issue as well, but it may be that they need more than just what the current law authorizes them to do. So there will be enforcement areas, interior enforcement, and so on that we will work on. That will then, I think, lead to needs to reform some of our legal immigration programs. The EB-5 program, which involves investors, needs reform badly, in my opinion. There will be need for legal agricultural workers if the mandatory verification system works properly, and therefore we need to work on that. I have introduced legislation to address that need in the past. Congressman Darrell Issa has legislation dealing with high-skilled workers, which is very important and relates to the statistics I mentioned in my remarks about how the United States, the most generous nation in the world, we give out more than 1 million green cards a year, but only 12% of those are related to education and skills that are needed in the country. And of that 12%, 7% are family members. So only 5% of 1 million plus green cards go on that basis. We need to shift that, and he has legislation that helps us do that. So that is an overview of this. But I think the first step is to see what this new president does. He said a lot about immigration. I think he intends to do a lot, but exactly what he does will set the tone for what we can do in the Congress to address all these areas, including the people who are not lawfully here right now. So I think that the president has shown that he's going to be very active in this area, and we'll follow that. Let's see, the lady standing in the back.
Hi, Jessica Da Silva from Bloomberg BNA. The Judiciary Committee came out with 2 bills that almost got passed last year dealing with adult criminal justice reform and juvenile justice reform. Considering that 1 in 3 adult Americans has a criminal record, what are the chances we're going to see some more legislation on that in this session? And if so, what would it focus on?
Well, we definitely will, both as a part of our criminal justice reform package. We passed 11 bills out of the committee related to that. But we will also be working on other aspects of criminal problems such as human trafficking, child sexual abuse, child trafficking, and so on. But we also will be addressing sentencing reforms and prison reform and prison reentry reform legislation. For the best idea of what it will look like, I would commend you to the bills we passed out of the committee, and some of those we passed out of the House in the last Congress. When? Soon, but we have a need to work with a new administration. We know what the last administration was interested in doing in this area. We need to have the opportunity to have an attorney general, so I hope the Senate will buckle down, that Senate Democrats will understand that a newly elected president needs a new cabinet, and that is, I think, going to help us with the timing on some of the issues like that. But I've already had conversations with the ranking member, so I believe we're going to work in a bipartisan fashion on this. All right, let's see. Victor.
As people here know, hey, thanks. As people here know, no one's done more for civil justice reform in Congress than yourself. And you have a bill to stop frivolous claims. Now, the last time I looked, frivolous claims don't have an R on them or a D on them. They affect everyone. Yet, when these bills go to the floor, there's this divide. The trial lawyers are very powerful, but do you see any path to be able to get at least some Democratic support for issues that are not ideological? They hurt everyone.
Well, you're absolutely right. It is a serious problem. It needs to be addressed. We do get some support, but not nearly as much support as we would like from the other party. That has not hindered us from passing legislation like this through the House, but it becomes a greater problem in the Senate. So obviously the Senate is in a new environment because a bill like this, which may not have been signed into law by the last president, probably would be signed into law by the new president. And so the Senate needs to look at ways that they can work on this area of the law. We're anxious to work with them. We know that everything we get through the House may not get through the Senate, but we would like to see them take up tort reform and other types of litigation reform in the Senate. Would be very, very important, and we'll sit down and work out our differences if they do that. But any message you can send over there on that would be good, and you're absolutely right. It's in the interest of all Americans to make sure that our justice system works fairly. All right, let's see. Yes, sir. Trying to go back and forth around the room here.
My name is Paul Morinville with U.S. Inventor. The effects of the American Invents Act were devastating to small inventors. As you work on patent reform issues this year, will you be bringing inventors in to testify to Congress? That didn't happen last time, which I think is why the effects are so devastating to small inventors.
Well, we definitely will. The American Invents Act, as you know, and maybe not everybody here does, was legislation passed early in the Obama presidency, and it was designed to deal with modernizing our patent office, to make it the review of patents more accurate, and to do them so that the patent holder would get the access to the benefits of the patent sooner rather than having a long period of time when it's being reviewed. I think that overall, I would say that it is achieving those goals. You obviously have a perspective that thinks that there are some problems there. So first of all, let me say, come on in and talk to our intellectual property staff, and we'll be happy to hear those concerns. But in addition, I think it's a good suggestion because we want to make sure that it is the small inventor as well as the small business that supports that small inventor by purchasing the product that they develop or licensing it from somebody. We want them both protected from false claims, from frivolous claims, from patent trolling. So hearing from them would be a good thing. Yes, sir.
Matt Laszlo with the Daily Beast and with Virginia Public Radio. I wanted to ask you, it came up in conference on Tuesday, did anyone on your committee staff sign a non-disclosure agreement with the White House around the executive order on immigration?
Well, first of all, it's commonplace for Republican and Democratic staff to lend their expertise to presidential transition teams. In fact, it's so commonplace that the Ethics Committee proactively issues guidance every presidential election cycle blessing this activity, and you can check that out on their website. Like I said yesterday in my statement, my staff on the House Judiciary Committee are some of the best on Capitol Hill. They are experts in their respective fields, and I was proud to allow them to provide their expertise and advice to the Trump transition team on immigration law. But to be clear, while they gave advice to the new administration, they did not have any decision-making authority on the policy. The final decision was made at the highest levels of the Trump administration, and I support the president's executive order. Yes, sir.
President Trump just, in regards to the nuclear option for the Supreme Court pick, said, go for it. Do you support the president on that?
Well, unfortunately, that's one role that the House Judiciary Committee would dearly love to have, but we don't have, and that is we don't have a vote in confirmation in the Senate. But I will say this, that when the Democrats 2 Congresses ago felt that they were not able to get their cabinet appointments, their ambassadors, and their judges confirmed, they changed the rules on all positions other than the Supreme Court to be able to confirm with a 51-vote majority. I frankly think that real democracy would be reflected in a Senate where all of their decisions were based upon a simple majority, or 51 votes. So the legislation that we just talked about here, I would prefer that the Senate have a rule that said if you get 51 votes, then any bill can become law. That would apply, of course, no matter who's in the majority in the Senate, because once it's done, I think it will stay that way. I will say this, that I think the effort of the Democrats in the Senate to reserve the the justices on the Supreme Court's position was one of recognizing the importance of that position. So far, the Republicans have agreed to continue that. But at the same time, I think they need to recognize the qualifications of the individual. And if these are all going to just be party line votes, then at some point that rule is going to get changed because we are going to have to fill the position on the Supreme Court.
Last question.
Yes.
Hi, thank you. You touched briefly upon the Copyright Office and the rules. Can you talk a little bit more about where you would like to see regulations implemented and what you think are the most important aspects that need to be addressed in the next coming years?
Well, there are a number of areas where I think it has been brought to our attention that work can be done. We are working very hard to build consensus. The first place where I think we have an opportunity to do that is in the Copyright Office itself. I believe that giving the office some more autonomy and giving the office the ability to modernize under the leadership of whoever will be the new Register of Copyrights is important, and I think that there's a lot of bipartisan support for that. So that's an opportunity that I look for to be able to act upon soon. There are a lot of other areas. I'll name some of them, but I don't want to say, you know, this is going to happen, because it really depends upon bringing people to the table who are willing to discuss reforms and being willing to give a little bit, because this is an area that is very hotly contested. But certainly the area of music licensing is something that has become exceedingly confusing, and there are lots of concerns that it's sort of not keeping up with consumers' new uses of new technology, new platforms on which to enjoy music. And it's also been brought to our attention that there is a disparate reward to people depending upon where their music is played, whether it's on radio or whether it's on the internet or whether it's on cable or satellite and so on. So that's an issue, but also related to that is the question of whether or not all the different people who work to create great music are being fairly compensated. We hear very much from songwriters, for example, that they don't feel that they're being treated fairly. So that's an area that is ripe for work, but I don't want to promise you that we're right out of the gate. But we'd like to work in that area. Another area is dealing with orphan works. We have lots of great work that it's hard, particularly with the lack of modernization of the Copyright Office, to find out who owns that work today, to be able to use it. And helping to address that would be a good thing. Another area is perhaps related to that is the fact that one of the areas where orphan works is a big problem are photographers who are, you know, taking a lot of pictures, and in this digital age, it's very easy to see your picture wind up somewhere where you're not being compensated for it. But a lot of photographers are very small businesses, and to enforce their copyright laws, they need to have access to the copyright legal system in a less expensive way than it can take right now to review copyright. So some type of a small claims process is also of interest. So those are just a few. I don't want to try to name them all because like immigration, there's a lot that we could do, but we're going to start with the Copyright Office itself. We've already put out, John Conyers and myself, a paper outlining where we think that should go, and you could expect to see work in that soon. Thank you all very much.